Great, thank you. And welcome to our session. And again, as said before, thank you to Suffolk for hosting us. So first of all, let's go through some introductions. I'd like to start with John. Go ahead and introduce yourself.
My name is John Harmon. I am a shareholder at Wolf Greenfield. We're the largest IP-only law firm here in Boston with offices in New York and DC as well. My personal background, I handle everything from patent prep and prosecution to agreement work, diligence work, a lot of general counseling with companies ranging from startups to Fortune 100 companies and the world-class institutions we have here in Boston. My background on technology is I have a mechanical engineering undergrad, material science PhD, work in technology areas ranging from med devices to consumer products, solid state materials, autonomous vehicles, robotics, and AI. I've been involved here in the startup scene in Boston for a number of years through various organizations, including Greentown, where I've done a number of events, as well as the E-Forum, where I started off on committees work that I did with them, and now I'm a volunteer board member there as well.
Great, thanks, John. Emma?
Hi, I'm Emma Tello. I'm an attorney for startups. I do intellectual property and business development, so IP portfolio management, registrations, business filings, licensing, and contract work.
Great, thank you. And we have virtual panelists this morning. Lara?
Hi, can you guys hear me?
We can.
Okay, wonderful. Technology worked. Hi, everyone. My name is Lara Silverman. I am based out in beautiful mountainous Salt Lake City, Utah. I'm sorry I cannot be there in person today. Seems like a wonderful event, and I'm really excited to participate. I am the founder and principal consultant at LAS Bioconsulting. It's a niche technical and regulatory consulting firm that I started 2 years ago out here in Salt Lake City. I work very specifically in the cell and gene therapy space, and also very specifically prior to clinical testing. So I see a lot of early stage startups and the trials and tribulations that the teams go through in order to be successful. Prior to starting my company, I was the head scientist at an allogeneic cell therapy company. I was the third employee and lived and breathed that startup experience. Before that, I got my PhD in bioengineering at Penn, and I got my undergrad degree in chemical engineering at Princeton. I'm super excited to be here today. Thank you.
Great, thanks, Laura. And my name is Dave Hall. So my background in startups is I did a startup in the Salesforce.com space 12 years ago. Now I run a boutique consulting firm called DLH Consulting, or Technology Advisors, excuse me. And I advise startups and different businesses. I do executive coaching, and I'm also a startup investor as well. So again, welcome to the session. So we're going to go over 3 different foundational aspects of a startup. One is IP, 2 is agreements, and then 3rd is how those interweave with fundraising as well. So I think that what we'd like to hear first is from a high level, John, where does IP come in when it comes to looking at different products? And on a foundational basis, how do you start when it comes to the startup space when it comes to intellectual property?
Yeah, great question. I mean, one of the things that you need to figure out first off is what IP do you have that you need to protect, that you want to protect, quite frankly, and this actually is much more than people realize. One of the things that you need to recognize is if you're going to have a startup, you actually need to make sure that you own the IP with the company. Because one, that's going to be expectation of the investors that you make. It also helps to avoid any conflicts that you might have down the road. So setting up those employment agreements, those founders agreements with the incorporation documents when you're founding your company. Also, consultants. Oftentimes people don't realize that consultants don't actually owe you any right of assignment of the IP they might generate if you hire them to come up with a prototype design or to do research. In fact, a client that we know of that in the past, they contracted with a research organization costing you a few $1 million to actually get that IP owned by the company. So that's where you need to start. Do you own the IP? Is it with the company? Do you have those rights? And then beyond that, it's actually well, you know, well, what tools do you have to actually protect it? Because oftentimes everyone just thinks, let's just outlaw trade secret. Oftentimes that's not the way it is. You think what trademarks do you're going to be doing a lot of brand recognition and work to get that name out there and to generate a lot of buzz. And if you find out, oh gee, I can't use that trademark in the future, you just perhaps lost years of goodwill that you generated. So think about that. Think about design patents, which a lot of people aren't aware of, as well as copyrights to potentially protect the look of your products or your websites or other things that are really associated with your company. And then that starts to take us to which is, well, let's think about trade secrets. Let's think about patents. But you can't just say, I'm going to create a patent. You need to think about, what is this IP doing for me? What is the business proposition that we have here? Because you can just spend a ton of money on IP and have it be absolutely worthless for your company. So you need to take that step back and say, what is the technological advantage that I have over my competitors? What is it that I can actually protect? Is this something where the second I release my product, everything is going to be known about it, so I have to patent everything that's new and unique and is giving me a competitive advantage? Or is this maybe I'm a software company that has a product cycle that's on the order of a year or two, and by the time you get a patent, you've already moved on to the next product, and it's absolutely worthless. Now, that said, software patents are absolutely critical in today's economy. So I'm not saying that software shouldn't be patented. In fact, but you need to think about how it's going to be used, where it's going to be used. Again, if it's something that no one's ever going to figure out and it's sitting on your server and you can keep it secret for the next 40 years, keep it as a trade secret. If it's something where you can figure out how it's being used, or it's going to be on your product that you're selling into the field and people will figure it out and you're going to use it for the next 20 years, probably patenting would be very helpful there. But you need to think about this strategically. You need to think about what tools you have in your belt, whether it be trade secret, trademark, regular patent, design patents, to come up with an overall IP strategy that's not just for today. It's going to be an IP strategy that is years down the road. That's the way you should be looking. And there are a number of tools you can use when you engage with an appropriate IP attorney or patent manager that you're working with. And you should be thinking about what's important, maybe doing some things such as patentability studies or landscape studies, where you start to figure out what's out there. What do I need to think about? What can I actually get? Because if it turned, literally, I have some stories where it looks like someone crawled into my client's lab, took a picture of the new design that they had sent us, and wrote a patent like 2 years before us. And this is where it really was, form was dictated by the function that they were developing. And while it wasn't good news for the client, it was definitely a good outcome for the client in that they didn't spend years and tens of thousands of dollars writing this patent and trying to prosecute it to get something that they absolutely would never get patent protection to. And that type of study can actually help strengthen your portfolio too, where there are times where we've found some of that art where it's not quite the one where it looks like they took a picture in the lab, but it's still close. It's maybe the next door lab. And what it does is it allows you to figure out, okay, these are the unique characteristics that I can pursue, and I need to focus my patent on that. I need to focus my protection around that, because then you get stronger protection versus if we didn't know about that, we probably would have tried to go after what that prior company had done. Maybe we don't quite disclose enough of what that feature is that we actually could patent. And you get into that tug and pull of, do you want to do the money up front, which oftentimes is good money for those patentability studies, versus just, we know enough about our market, we're confident, and we just need to move fast and file a patent in. It's just a business decision at that point as to which one's the best one to do.
Yeah, we're definitely going to have to talk about the software side, patenting versus not patenting. Let's table that. But I've got an interesting anecdote that I want to bring up, and we'll talk about that in a minute. So Emma, your thoughts at a high level on IP, as well as, there are thoughts out in the marketplace that say when a higher education entity owns or is part of a patent portfolio, some investors they can, as I would say, run for the hills and don't want to be a part of that process. People have said that has changed. You know, what's your perspective on not only the high level, but, you know, when John talks about assignment?
Yeah, so oftentimes when you're dealing with the university, it's because you have federal funding and you need university equipment, or you are a research professor at a university. And generally, universities will have a clause that anything that you come up with when you're working with or for them, they own. And that becomes difficult when you're a private company who has like federal funding and you're just looking to use university equipment. And that's where like sponsored research agreements come in, where you work out those terms. And oftentimes you can negotiate these terms. And it's really important to be able to read your contracts, know what your rights are. And usually what you'll do is you'll get an exclusive license to the intellectual property that you're working with, where you have the exclusive rights to patent and sell the technology that you're working on. And that's just something that you have to negotiate. And oftentimes, if you choose not to patent that information, maybe it's not in line with what your company is, then the university is able to take that and patent it on their own and market it as their own.
Comment. Go ahead. Absolutely.
So one thing to think about, and this actually goes, one, I completely agree with you, Emma, in that when you're doing the sort of targeted research or use of facilities, setting up the agreement where we're just using your facilities, we're paying you for a service, we're not paying you to be able to own the IP that we're generating. But one of the things when you're negotiating with universities is they're actually not allowed by law oftentimes to directly assign the rights to you. So the most that you will get out of them is an exclusive license. And you can usually get favorable terms, especially a lot of universities like it when companies are spinning out of their facilities, and they oftentimes will offer you options for that exclusive license, so you don't perhaps have to pay them everything up front for what they've done. But also, many investors are going to expect you to have some of those rights if it's necessary for the inventions or the new products that you're coming up with. If it was spun out of that lab at the university, perhaps there is some foundational IP that would be blocking if you don't have some sort of right to use it in the future. And so it's important to think about, what product am I coming up with? How do I tie this to the IP at the university? And do I need a license to the university? Because it does, as Emma was saying, it does come with strings attached. If it was federally funded, they're going to have all the BIDOL requirements, which, to put that in normal terms, basically says you have to have U.S. manufacturing preferences, you have to have certain restrictions on government rights. But usually, even though they sound scary, they're usually not quite as bad as many people figure out. But you do need to think about it thoughtfully. You do need to have a story that you're willing to tell investors, and to have that story make sense. Because if you don't have that story and all your sort of all the check boxes put in a row before you start talking with people, it is going to raise questions. And if someone beats you to the punch and licenses it out from under you, maybe you lost the rights to do your entire enterprise if it covers the entire field that may have been developed out of that lab.
Yeah, if I could I build on that a little bit? So I actually wanted to touch on field of use, because I think that's really important. And I recently had a client who had defined a field of use for some intellectual property that they licensed from a university, but they had an overly narrow field of use in their contract. And so now we're having to go back and haggle with the university to expand it, because as they were doing research, they actually discovered that some other permutation was more appropriate for them to commercialize than the initial very narrow indication. So I think fighting for a more broad field of use, or at least trying to anticipate where your research might go, is really important. I would say when it comes to licensing IP from universities, expect it will take longer than you think. It can be very difficult and challenging, because the university thinks they have the best sliced bread, and you might be trying to pick up 5 or 6 different pieces of intellectual property. You have a very tight budget as a startup, and so that back and forth can actually take a long time and can be quite challenging. So establishing a really good relationship with the tech transfer office and trying to start at a great place of sort of mutual understanding can really streamline some of those negotiations. But they are really critical. And then maintaining a good relationship with the lab is important, continuing to do research, setting up a sponsored research agreement. That relationship with your university is golden. So you want to really cherish that and nurture that. But just don't underestimate how long it takes to license and make sure you get a really good lawyer with experience who can do things like point out, oh, that field of use is really narrow. Why don't we try to broaden that out? I think that's really important.
Okay, so I'm the dummy in the room, okay, and I want to know what the difference is between field of use and freedom to operate. Or are they the same thing, or are they two totally different subjects?
Very different subjects.
Okay.
Where freedom to operate is whether or not somebody with a patent that perhaps you're aware of, perhaps you're not aware of, they can stop you from making whatever product or offering whatever service that you're offering. So it's basically other people's rights to stop you. Field of use is basically, if we start talking about licensing agreements where we're talking about, I have a patent, I want to license it to you, you can either say field of use or territory restrictions on it, where you can say, I'm going to license you the ability to make this product. I won't sue you using any of my patents in the US or in China or worldwide. Or with regards to field of use, maybe it's that your new technology has an application in solar panels, but it also has applications on surfaces in the medical field, because maybe you came up with like some beautiful way of modifying the surfaces for either sanitization or cleaning purposes, and maybe it wipes off the dust in solar panels and it kills all the bugs on the operating table. And so defining what your proposition is for your product, thinking about how broad you want to be able to sell and do things, can be critical for, quite frankly, including value in that license you're setting up. Where I was recently negotiating a license, and when I looked at the field, it was absolutely way too narrow. They basically said, this was the research you did in the university, that's all the field that you're getting. And I'm just thinking, this technology can be applied to literally any surface that you want to play with. And we just completely rewrote the field, completely rewrote the territory. And something else to think about is those terms can absolutely impact how much your royalty is being paid, how much where you're allowed to operate. And so getting someone that has the IP experience, the licensing experience, either on the business side or both perhaps, can be really critical, because you may be licensing this at the beginning of your startup journey, but this will impact you for potentially decades.
Ever. Forever.
Yeah, forever.
Yeah, exactly. Exactly.
And field of use also comes into play when you're patenting your invention. Say you have a widget that is really good at XYZ, and so you patent it for XYZ, but also someone discovers that it could be used for doing ABC, but you never mention ABC in your patent application. They can come in and say, well, this is a novel and non-obvious use of your widget, so I'm going to patent it for this. And then you lose rights to be able to use it in that field.
Understood. No, that's great. Okay, so the next issue we're going to talk about is fundraising. A lot of times I hear entrepreneurs and founders, they talk to investors and they'll say things like, oh my goodness, this investor won't sign this non-disclosure and it's driving me crazy. How does IP and agreements like that tie into starting that fundraising process, at a high level? Emma, what are your thoughts there?
So before you disclose any of your confidential or proprietary information about your business model, what you're trying to invent or sell, you should always have the person that you're disclosing to sign an NDA. Because if they do not sign an NDA, they are free to use that information however they want. And a lot of times investors will be hesitant to sign an NDA. And this is where, again, you come into negotiating the terms of the NDA, or confidentiality agreement. Usually you'll want to define a specific scope of use for that information, as well as a term for how long the information remains confidential, how long that investor or other party has to keep that information confidential, and different terms, whether it's a one-way confidentiality agreement, whether both parties are disclosing information to each other, and also whether that information is being used for investment purposes, whether you are trying to create intellectual property together, and that's where the ownership and licensing comes in as well. if you are working with a party that says absolutely not, I will not sign a confidentiality agreement, that's where you don't disclose your confidential agreement. Do not pass go, do not do it. Disclose information that's already been made public. Maybe you have filed a patent. Say, okay, well, we filed this patent, so here's that information.
Yeah, so I'm going to put my investor hat on for a second, okay? Because a lot of investors say, listen, first of all, if you're going to send a slide deck in, it should only have non-confidential information in it, right?
Right.
Or as the lingo would be, non-confi slide decks, right? You know, whatever. And the reason why is because of a lot of investors, if they like what they see, they also want to bring in other investors and want to share that deck with other people. Well, guess what? They've just broken the agreement that says you've got a non-disclosure agreement and you can't do that with a slide deck. So what's the feedback there, and how do you get around that, John?
So that actually, especially with larger investors, they have so many people approaching them. They refuse to sign NDAs with any of these parties until they really, really get serious and say, we have to see your confidential information, where they say, keep it at that high level, keep it at something that isn't going to be confidential. But one thing is that this always has to be balanced up against what is the business need of the company, because you do need to disclose something, because otherwise no one's going to know about you. They're not going to know about this cool new product you came out with. But how do you get that balance? And well, one of the things you can do, and Emma touched on this, file your patents first. Once you have those patents on file, you can go, as long as you don't think that you're going to come up with a bunch of new things that you might need to patent tomorrow that you also want to talk about, you can start shouting that from the top of the roof if you want. And it's completely fine, at least from an IP perspective. And once you've done that, you can start putting that into your slide deck, giving a little bit more details as to what you're doing. And so you don't have to be as worried about it being confidential information. Now, let's say that you are in a position where you do need to provide some of that information, or at least the benefits of things. Like how do you balance the need to disclose the information versus keeping confidentiality, where maybe they won't sign the NDA, you don't have the patent on file yet. Think of ways that you can black box this. If someone doesn't know what you're doing, but you can say, here are the benefits, like maybe you say at a very high level, we came up with this new compound for battery materials, and we get like twice the capacity of everybody else's. We're like twice the power as well. And here's all the curves that show us on the comparison. You don't have to tell them, here's our specific composition.
Yeah, the secret sauce,
you don't
right?
have to give them the secret sauce.
Right.
Exactly. Keep that secret sauce secret. And then when they ask for you, hey, tell us the composition. How are you getting to that? You say, well, we showed you the stuff that's public.
Sign the NDA.
At this point, if you want to know more. But that's the way that you always have to do that balance between the business need, the disclosure, the marketing, and keeping things confidential that you have to keep confidential to avoid loss of IP rights down the road.
Got it.
Yeah.
Mara,
To build on
there.
Yeah, so to build on that, I would say, I think when you're starting to think about fundraising, fundamentally, you need to plan two different pitch decks, right? You need to sit down with your inventors and with your business leaders and say, what are the things that we can hook people with in a non-con way? And then what is the actual confidential information that we would disclose once we sign a CDA? And you need to hook them, right? You need to have something that's novel or exciting, or it's going to solve an unmet medical need. And you need to find a way to communicate that. Oftentimes in my field, we'll, for example, include some data, but take the axes off. So, you can say, look at this huge benefit, but you're not necessarily disclosing the details of the magnitude of the benefit. So there are things you can do to hook your potential investors without actually disclosing anything. And it's really critical to do that because there can be so much noise in the space, especially if you're sort of an incremental improvement. But if you believe fundamentally there is a benefit to your technology and you have the right team and the timing is right, you really want to try to draw them in. And so in that non-con deck, you also can focus on things like who you are and your experience and what's different in your business model, and just try to draw them in so that when they do sign that NDA, then you can start to really dive into the technical details. Honestly, in my experience, the technical details you won't even get into with an investor until way down the road, right? They're screening all these other things first. They're assuming this, in my experience, they're usually assuming the science is pretty dang good, right? And they want to screen all this other stuff first, and then they'll get to the really confidential stuff. So don't underestimate the importance of those first impression, the first impressions, and the other information in your slide deck that's drawing in your potential investors.
Yeah, and that's where the appendix in your slide deck is perfect, right?
Mm-hmm.
If you've got that confidential information, put those slides in in the appendix. And once they've signed an agreement that says we won't disclose any of that, that's where they'll ask the question, well, what about the science of this? Oh, let's go to slide 56, as opposed to the first 12 of that introduction. So that's where the appendix is absolutely perfect. But having access to that data to be able to discuss that with investors is super important. So, okay, I want to get back to that software issue though, because this is a hot item for me. So back when I founded Kona Data Search in the Salesforce.com space, we were thinking about patenting our software, but I bumped into Gordon Ritter from Emergence Capital, very successful investor on the West Coast, one of the only investors in Salesforce and multi-billion-dollar company Viva, very successful. And we're walking along, and I'm chasing him because who knows where he's going next. And I'm like, Gordon, what do we do? Should we patent this, or should we, or not? He goes, if you're doing SaaS 9 times out of 10, it's all about customer acquisition. He goes, don't bother with the IP side. So I want to hear, your thoughts, both of you, all three of you, on, if you have any, on do I patent software or don't I? And if you do, what are some of the nuances there of, in this particular situation?
You're going to love this answer. It depends.
Oh boy. I don't want the skill set, okay? Come on, I want the detail.
Well, that's the lawyer answer. It always depends. And
Yes.
the facts of the software, the facts of your product are going to really impact whether or not you use software. To go back to the example I was talking about a little earlier, where if you have a product cycle where, let's say it's some little app on the iPhone and it's going to have like a 6-month shelf life before everybody forgets about it, don't bother with IP.
Right.
By the time you get some sort of protection, it's already forgotten. People have moved on. It's not one thing. If instead you're talking about software that is very evident in the way that your process or your device is being operated, and it's going to be critical for you to get that coverage because it's going to be in your product for the next 20 years or so, that's something where you should start thinking about, is IP something that is valuable for us to get protection for? And the reason for that is that, let's face it, you get a ton of fast followers in today's economy. And if you don't have something that's going to be around and it's going to be critical for your product and the viability of your company, when you start talking about value propositions to investors, because they want to know, how are you protecting this value add of your company? If you simply tell them, haven't thought about it, that's not a good story. They're going to walk out the door. But if instead you say, well, these are the aspects of our software, we can tell if someone's operating it just based on the way this physical device operates. If it does this, we know that they're using our algorithm that we came up with. And we have software that protects it. That part is a nice story. It's an enforceable story. But then we start getting into those other cases where, let's say we have a process, it's on our server, no one will ever know that it's there. I can't tell what someone else is doing. Basically, you send data to the server, it comes back with maybe this is how you should operate your autonomous vehicle, or this is some stuff that's upcoming in front of you. And it could be done in 50 different ways, and you have no way of telling what they're doing. And no one can tell what you're doing, quite frankly. And you can keep it secret within your company. Maybe that's something that you keep as a trade secret. So it's going to be that pull between, can I detect infringement? Can people figure out what I'm doing? If something's on your device that you're selling to people, trust me, someone will reverse engineer it. I used to be paid to reverse engineer people's stuff.
Exactly.
And I told people how to get around their patents and to do everything else for them, because I used to be in consulting engineering and science back in the day. So don't think that people won't figure out what you're doing if you release it in the public. They absolutely will. There are many smart people in this world, and they're very motivated to figure out what you're doing if you're successful.
Got it. Emma, any thoughts in this space?
Well, one thing to consider if you're trying to decide if you want to patent your software or keep it as a trade secret is also the components of that software. If you have any open source software as part of the component, you can't patent that open source aspect because it's public. And one thing that clients have trouble with is they will file a patent, go for it, get it examined, and then they can't patent it. The office says, no, absolutely not. And then not only do you not get a patent, that information is then public and anyone else can use it. So you have to really consider, this is where like freedom to operate, patentability reports come in, because if you can keep it a trade secret, then maybe that's the best route to go, depending on how long it's going to be in the market, that sort of thing.
I would say it depends on the type of open source, because many companies rightfully do want to do open source and use open source because, let's face it, you don't want to have to rewrite just the latest little ticker that you want to include on your graphical interface or your GUI. But you need to be aware of the license terms. There are some license terms where some people think that you shouldn't patent anything software, and that's where you get into the copyleft things that you're referencing. And those basically, you're promising your firstborn child to everyone that comes after you. Don't use them, run away from them. That you're giving up so many rights for your company, it's not worth it. If you insist on using open source, be aware of the types of licenses associated with the open source that you're picking. Pick something that's permissive, the MIT license or the unlicensed, or something where they just basically say, we give it to anyone for any purpose. Have fun with it. But if you pick the wrong one, it's a huge issue. And we'll touch on this a little bit later. It absolutely comes up in diligences, and it absolutely will kill the value proposition for your company. If you basically say, like, everything we came up with is open source and it's all copyleft, that investor will run out the door.
And just because you might be able to use the open source software in a patent, if your use of it is not novel and non-obvious, then it will not be passed through the examination office as well.
Got it. Understood. Laura, any thoughts in this space?
You know, I work with cells. I work in biology, so we haven't had as much interaction with the software space. We have our own challenges, particularly with, needing to license many different patents, but and also groups forgetting to patent before they publish. That's often a thing that happens in biology labs when they're moving quickly, but software has yet to break in. I know there's a number of questions around AI in the chat. We're hoping it will hit our field, but it really hasn't yet.
Got it. Understood. Okay, so the third area that, once you've got your IP going, you've got millions of dollars in the bank with fundraising. Now, what about, agreements with folks that you're working with as far as employees, contractors? And Lara, you had brought up, basically, how do you build the culture? And, so I'd love to hear your feedback on, this critical issue as well.
Yeah, I think this is really important. And sometimes we can get so busy with lawyers and, IP and corporate structure, we can forget some of the basic principles of the fact that you're bringing together a new group of people that are moving forward with the same goal, with a common goal. And it's really critical in these early stages of a company to define a culture that you want to flourish over the next 5, 10, 20 years. And to remember that everyone's going to look to you as the leader and emulate your behavior and the way that you operate. And there's some things that you can do that are really defined. You can write your principles on the wall. You can, set up sessions where you specifically talk about it. But there's also the intangible way that you operate and you need to know that everyone's watching you all the time. As you build your team, for me, I work with startups. And so there's really many different ways you can do this. Some will choose to run very lean and slim, and they'll maybe have 1 or 2 employees, and they'll pull in a lot of different contractors and consultants and CROs and CDMOs. And I think that's a really valid and streamlined way to build a business. And perhaps in that case, culture is somewhat less important, but not really, because you're still bringing in these people who are trying to move your idea forward, and you want to make sure you're really supporting them. And the opposite approach to that, of course, is that you hire, and you really build your internal assets and your people assets. And that's also a really great way to build a business, especially when you have multiple assets in your pipeline. If you're a one-trick pony, that can be harder to justify. But if you're really a platform or you have a lot of different technologies you're trying to move forward, I think building a team is really critical. And in that setting, that's where that culture is so critical. Thinking about things like, working from the office versus working from home versus hybrid. These are really hot topics that when you're thinking of hiring, people are going to ask you about. Also considering the blending of generations and the differences in how people work of just different generations. I think there's a lot more awareness of that now, and there's a need to be sensitive to that. So, the startup world, yes, we've been talking mostly about IP and contracts. That's very, very critical, but you need to also really spend time thinking about how you're going to build your culture and be successful, in the way that you see fit, right? You're the founder, you're the one that's trying to build this company, and it's up to you to define what that success might look like. So.
Great. John, any feedback on this space? Or Emma, when it comes to, agreements and employees, contractors, on the legal side?
Well, I'll go back to confidentiality agreements. Anytime you bring an employee in, you should have them sign a confidentiality agreement as well. Maybe you have non-solicitation clauses depending on what state you're in, because you don't want someone to come in, really study what you're doing in depth, and then leave 6 months later and start their own company. But it's also important to make everyone feel like you're on the same side. Like, you don't want them to feel like you don't trust them. So it's definitely a fine line to walk.
Mm-hmm. And as part of that, just again, the assignment and the employment agreements, and in addition to the confidentiality, and oftentimes setting up exit interviews for within companies when people leave, sort of kind of reminding them, hey, you signed these agreements in the past, not saying you'll do anything wrong, but you really should be aware you're still bound by these agreements. You can't go tell people. If you have a non-compete, depending on what jurisdiction you're in, sometimes they're valid, sometimes they're not, telling them about the non-competes they have, reminding them of the confidentiality requirements, et cetera, and that they still need to cooperate with you if they still need to sign things in the future, or if you have patents that need to have forms signed, they still need to sign those. Setting it up in a thoughtful manner so that you have a good practice around it, that it's handled thoughtfully and not sort of like ad hoc or in a mean manner. That's very important, because oftentimes when these people leave, you would like them to leave as on good terms as you can. Sometimes that doesn't always happen, but you may need these people in the future.
Absolutely. Yeah. So we're getting towards the end of our session. Lara, could you give us a little bit of help on some of the online questions or chat?
Yes.
Are there any specific questions?
Yes. The first question that I thought we could cover is, when should patents be submitted? Which I think is a good question. I'll let the patent lawyers address that.
Besides ASAP.
Yesterday. The answer is yesterday.
Submitted before you publish anything. And publications include written publications, presentations, slide decks, anything that somebody could listen or read what you have and then take it and use it. Because so when you patent something, if you are doing like a non-provisional patent, you have 1 year before you have to file a non-provisional. And you're protected. You have patented that, you are good to go. You can shout it from the rooftops. If you publish and then write your patent, you have to deal with the timeline of everyone who has heard your publication. There's a year in which you can patent it. However, if a third party comes in, takes your information and files that patent before you, then you're out of luck. The US runs on a first to file system. And if you publish and then don't submit a patent for a year, that publication is now prior art against you. Even though it was your own invention, you lose that right.
And one thing to think about is the second you publish that without having a patent on file, you lost all your foreign rights. So if you want that European patent, the Chinese patent, which investors will expect you to get, you won't. And something else to think about is many times people don't think that confidential sales would count as a publication or a disclosure to the public, where here in the US, we're rather unique. Even if it's confidential, if I sell something to someone, let's say that I came up with a new and this is not the exact fact pattern, but it's an example close to a fact pattern I heard of. There was a startup, let's say that they were making a new process for fertilizer manufacture. They don't tell you what the manufacturing process is, but they've been selling that the fertilizer they came up with, and they've been selling it for more than a year. Guess what? In the US, you're not getting a patent. So before you sell something, before you talk about it, before you upload that video to YouTube and show it to your friends, before you talk with your dorm buddy, file your patent first. Maintain your rights. Keep it safe, keep it secret.
Good advice. Good advice. The other question that we have here is, how are things changing with generative AI?
A lot. Well,
Boy, that's a wide open question.
Yeah.
very, very wide open. That can run the gambit from using generative AI to come up with an invention. There was a recent court case that basically said that the AI was not an inventor and the person didn't get their patent for that. That's because the person was being trying to make a point rather than get a patent. He should have just listed himself as the inventor. If he had listed himself as the person that came up with the generative AI, came up with the prompts for the AI, listed himself as the person that came up with it, he probably would have gotten his patent. Instead, he was silly and didn't listen to his probably advice from attorneys and wanted to just fight this point, and he lost. Now, if we turn to the other point about generative AI, of using it to come up with something, there are some huge questions in the legal field right now about public disclosures. If you use AI to come up with an invention, and let's say it's just ChatGPT, I have no control over where they got the code from, where my information goes, whether or not my information might be used in the future as an update to their model that they're then using to give other people information and answers. That could be a public disclosure. That might be considered that I can't get my patent because I disclosed that when I uploaded it to ChatGPT. But the use of trained AI models, it's not going away. We use it. I've used it in everything from cancer detection type of applications to image analysis, things that I work on with people, to path planning for robots. It's here. It's real. We do get patents for them, but you do need to be thoughtful about it. And preferably, if you're a business, if you're going to be using a model or an AI to generate inventions, don't use ChatGPT. Use something that's private, specific to your company. Pay someone for their service of, hey, here's the model that we've trained on this clean data set that we know that you want to use, and you can use it just for your stuff. It's internal to you. It will never be public. So that's some of the ways that the use of AI is going right now, but it's still absolutely an evolving field. Great,
thank you. So I think we're getting the notice to wrap things up. We appreciate the time today. John, Emma, Lara, thank you so much, and thanks everybody for joining. And have a great day and a fantastic weekend.